Alex here with part 190 of the My Docket series on child custody and visitation. As in my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. My mindset for this video, which is going to go over my reply to my ex's opposition to the ex parte motion, is extremely frustrated. I can remember being frustrated, and that is because I didn't understand why this attorney felt it was appropriate to respond to this specific ex parte motion, but not to the other two motions that I filed. If you guys can recall, the other two motions, which were, one was the omnibus motion to do a whole bunch of things, but the main one being, if I remember correctly, a continuing duty to disclose her physical address. The second one was the motion for order to show cause. And both of those, the attorney responded on opposition saying he really didn't have an opposition because he couldn't get a hold of his client. And he said he's trying to withdraw from the case. He doesn't have anything to say. He's only filing an opposition because he wants her to at least have a hearing, an opportunity to show up at a hearing and explain herself. With this ex parte motion that I filed, all of a sudden, he does have defenses. He files an opposition and he puts in all sorts of defenses. And the thing that really frustrated me is I just didn't understand why the same logic now didn't apply then. The issue was much more urgent now. It's an emergency situation because she's trying to get the ability to exercise visitation while concealing her residence. And for whatever reason, he decides to actually go ahead and respond for her. This was, in my opinion, very inappropriate because he didn't get an affidavit from her to verify the opposition. It was not sworn under penalty of perjury. On the one hand, somebody might say, well, he probably can't get a hold of his client because there's not enough time. But that doesn't really apply in this case because if you look at the other two motions, he already couldn't get a hold of his client even to respond to those. And he would have presumably had at least a couple of weeks to try and get a hold of her. So in this particular situation, it's improper, in my opinion. He shouldn't have done that. I still blame the judge mostly, not the attorney. Most of the blame goes, in my opinion, to the judge because the attorneys have a job to advocate for their client. And oftentimes that means bending/breaking rules for their client. If you look at the video, Win at All Costs, you'll see the details on my perspective with regards to that. It's more complicated than it seems. It's not just a video that bashes them. It goes into a lot of detail. Anyway, all that being said, I really think that we are going to just have to go into, what I have filed. Here we have the reply to opposition to ex parte motion for temporary suspension of visitation. I notice this document isn't too large. It looks like it's just 3 pages. My suspicion is that I refer, for the most part, to the omnibus motion. That's going to contain a ginormous factual background. That's going to contain all the points and authorities. The only real thing to point out here, I would imagine, is to say, hey, you should look at that motion. Anyway, I am stating here in the standard introductory paragraph that I am the petitioner. I'm introducing myself to the court, indicating that I have no attorney, that I'm appearing in proper person, and that I am filing a reply to my ex's opposition to that ex parte motion that I had filed. Respondent, my ex, to the best of my belief, resides in Reno, Sparks, or Carson City. I'm not certain as to where. My ex has indicated that she will stay with the child at a hotel, but has not indicated that this is where she now resides. The child has communicated to the therapist, his mental health provider, that on arrival he will occasionally spend a number of days in a hotel, but that he subsequently will spend his time at his mother's residence. To date, all that is known is that the residence is a house and not an apartment complex. I am not asking to know exactly where the child is at every moment in the visitation. I can't even believe I have to say this. They just cook up these inane arguments and try to stick you with them. Anyway, my ex is free to take the child to the movies or on hikes at will. I'm only asking to know where she resides for the 50th time. Next paragraph. This is a highly contentious child custody dispute. There are more than 100 entries on the docket and over 40 orders have been entered by this court. Never before have I filed a motion to suspend my ex's visitation. Never before have I denied my ex her scheduled visitation. There are only 2 motions pending, each addressing a variety of serious issues that need resolution by the court, and I have only insisted on the compliance of one of those issues before allowing the child to travel with my ex for her visitation. Again, guys, I feel like if this was a mom who was asking for help because the father was saying he wanted the child while keeping his residence concealed, that the court would have jumped all over that. But it's not the way it's working. Instead, we have the mom who's complaining that she doesn't get to see the child and that she should be able to keep her residence a secret. And I've said this many times before, but if you want to know where it comes from, please watch my video on the topic, gender bias. That one issue is knowing where my ex resides. Hypocritically, she has at all times insisted on knowing where I reside, and I have always made sure to keep her up to date on my physical address throughout the years. And that's true. She's never, ever not known where I lived. And I, up until this point, have never, ever known where she has lived. It might surprise this court that my ex has even used this knowledge to travel to my home against my wishes. And then here's me referring to the affidavit of Chris Hassler. I have opposed my ex's request for reimbursement of transportation and hotel expenses. My ex could have ensured the visit went smoothly simply by placing her address into the info bank of the Our Family Wizard. Alternatively, my ex could have sought to hold me in contempt of court, arguing that she's justified in keeping her address secret and that it's against the best interest of the child to know where I reside. Instead, she's reputedly refused to disclose her physical address despite the court's previous admonishments and obstinately purchased tickets that she knew would go unused. Rule 5, Certificate of Service. Here I have the certificate indicating that this document was served upon my ex's attorney. And that's the whole reply. I'm surprised there isn't more to it, but I guess there isn't really much more to say. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney filed nothing, so he incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have still charged her to review this. I think 15 minutes is a reasonable amount. At the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.